Welcome to CRJ 134. This week we're taking a look at two different chapters. Chapter 13, which looks at juvenile justice, and then Chapter 14, which explores police work with juveniles. So when we look at juvenile justice in Chapter 13, we have to look back at the beginning of the 19th century and realize that delinquent, neglected, and runaway children in the U.S. were really treated the same as adult criminal offenders. So during the early part of the 19th century, there were various pieces of legislation that were introduced to really humanize the criminal procedures for children. Now, many books and reports written during that time really heightened the public interest in juvenile care. However, there were no special facilities that existed for the care of youths that were in trouble with the law, nor were there separate laws or court to control their behavior. So this chapter really kind of discusses the child savers in the House of Refuge. So when the House of Refuge opened, the majority of children that were admitted to it were status offenders. Now, because child savers consider parents of delinquent children to be as guilty as convicted offenders, they sought to have reform schools establish control over children. Now, there's still debate that continues over the true objectives of the early child savers. Were they really what they seemed? And so you have to think about this. What do you think about their approach to saving children? Now, in the course of saving children by turning them over to these houses of refuge, the basic legal rights of children were violated. There are many children that were simply not granted the same constitutional protections as adults. Now, ultimately, this movement culminated in the passage of the Illinois Juvenile Court Act of 1899, which established the nation's first independent juvenile court. Now, make sure you take a look at the key provisions of the Act. The major functions of the juvenile justice system really were to prevent juvenile crime and to rehabilitate juvenile offenders. Now, do you feel those functions are the major functions of the juvenile court today? And what are some of the primary ways that the juvenile justice system has changed between 1899 and now? Now, reform of the juvenile system really was slow in coming, and it didn't really begin in earnest until the 1960s. Now, during the 1960s and 70s, the U.S. Supreme Court radically altered the juvenile justice system when it issued a series of decisions that established the right of juveniles to receive due process of law just like adults did. So make sure you review the leading constitutional cases in juvenile justice that are presented in Exhibit 13.1. Now, today, the juvenile justice system exercises jurisdiction over two distinct categories of offenders: delinquents and status offenders, and it exists in all states by statute. Now, most children come into contact, with the justice system with that first contact with a police officer. Now, once they go to court and after disposition in court, delinquent offenders can be placed in some form of correctional treatment. Now, probation is the most commonly used formal sentence for juveniles. In many states, the youth must fail on probation before being sent to an actual institution, unless the criminal act is very serious. Now, do you think that that approach appears to be effective? Now, as the chapter finishes, it talks about a comprehensive juvenile justice strategy that's really been called for to deal with all aspects of juvenile crime. And the strategy really focuses on delinquency prevention and expanding options for handling juvenile offenders. So what kinds of changes do you foresee in the future for juvenile justice? If you had the power to implement wide-scale change on your own, what types of changes would you suggest? Now, Chapter 14, when we look at police work with juveniles, it really begins with the history of juvenile policing. And so, I guess a good question would be, what do you think is the primary responsibility of the police regarding juveniles? Is it to protect the public or something else? One important thing to remember is that working with juvenile offenders is probably one of the most challenging aspects of being a police officer. Now, the alarming increase in serious juvenile crime in recent decades has made it obvious that the police can no longer neglect youthful antisocial behavior. Police who work with juvenile offenders usually have certain skills and talents that go beyond those generally associated with regular police work. So do you think that officers who work with juveniles need to meet special requirements? And what should those requirements be? Also, what skills would be beneficial to officers have to be successful in that area? Now, in the past, police often questioned juveniles without their parents or even an attorney present. Now, in 1966, the Miranda case, the Supreme Court placed constitutional limitations on police interrogation procedures with adult offenders. The Miranda warning has also been made applicable to juveniles that are taken into custody. Now, one problem associated with custodial interrogation of juveniles has to do with the waiver of Miranda rights. And an important question is, under what circumstances can juveniles knowingly and willingly waive the rights that are given to them by Miranda versus Arizona? And do you think that a young person acting alone without guidance of a parent or an attorney has the sufficient maturity to appreciate the right to remain silent? Or at what age does that happen? Now, today, juvenile offenders receive nearly as much procedural protection as do adult offenders. However, the police do have broader authority in dealing with juveniles than with adults. Now, do you think that police have too much discretion when it comes to dealing with juveniles? Now, there is a lot of discretion that's exercised in juvenile work because of the informality that has been built into the juvenile justice system, really in an attempt to individualize justice. So is that a strength or is it a weakness of the juvenile justice system? Do you believe that police routinely use racial profiling when they decide to make an arrest, whether it be an adult or juvenile? Some experts do believe that police decision-making is deeply influenced by the offender's personal characteristics, whereas others maintain that crime-related variables are more significant. So should police discretion be limited? Now, one last aspect here regarding police work with juveniles is, in schools across the country, there are more than 14,000 full-time police that work as school resource officers. So think about this. If your school had a resource officer, think for a minute about that experience. Did you feel safer having them there? Is it important to have them there, or is it something that's unnecessary? Or does it provide more than just protection? Does it provide an ability to form relationships with young people? Now, next time we'll take a look at Chapter 15, which explores the juvenile court process.